Ms. Bernstein, are you with us? You're on mute, Ms. Bernstein, if you're trying to respond and your video is still not on. There we go. All right, thank you, Ms. Bernstein. Mr. Pellegrino, we're ready. You may proceed.
Good morning, Your Honors, Judge Silberman, Judge Smith, and Judge Atkinson. May it please the court, my name is Paul Pellegrino. I am the appellant, and I will be representing myself today because I have to. This case directly affects my integrity in the eyes of my only daughter, Gianna, who is 17. I will remain cognizant of my time allotment, and I respectfully ask for the 5-minute rebuttal.
Very good, Mr. Pellegrino. I'll let you know when you get to that point.
Thank you, sir. This entire case centers around the mutually agreed to child support contract that Stacy Lang and I entered into during October of 18. It was absolutely designed with the best interest of our daughter in mind. Like Mr. Jackman said earlier, this is my first time ever doing this. So please allow me 2 to 3 minutes just to provide a clear picture and a logical pathway before I jump into the index of records, please. This case is rather simple. There are only 3 issues. On November 5th of 19, that's the day I finalized prepaying child support to the appellee for $19,000. In return, the mother agreed to waive all remaining child support payments through her high school graduation in June of 2023. Second, on November 30th of 20, the appellee contacts the Department of Revenue and falsely accuses me of not paying her during the time period of May 1st, 19 through June 30th of 2021. And lastly, Department of Revenue never once questioned the appellee's accusation or motivation in this case. Please let me assure this court, I am not here objecting to financially taking care of my daughter. I always have, I always will. She is the reason I agreed to move to Florida with her mother so that we can provide her a better lifestyle and that she could attend high school and college here in Florida. At 65 and retired, she's the #1 priority in my life. I am here, however, objecting to this FASO, as well as the Department of Revenue labeling me as an irresponsible father, a convicted deadbeat, and believing that they know what's better for my daughter than I do. And that's unequivocally not true. If you have children, put yourself in my place. This is very personal to me. It is not a job assignment. I say convicted because the Department of Revenue in February levied $13,000 from my bank account, knowing very well that, okay, today's hearing was pending. There are 4 major turning points to this case: probable perjury, administrative oversight on both sides, a jaded FASO, and an unforeseen extenuating circumstance. Before I proceed any further, I'd like to make one concession. I do not have a law degree like everybody else that's present here today. I did invest the time, though, to watch a number of oral arguments previously and to read as much as I could about the rules and procedures of this court. And I have to honestly say, I won't be reciting any case law or any Florida statutes because that's way above my pay grade. I only intend to stay focused on the truth and facts that are on the record as I address a number of the Department of Revenue's arguments. If I cross any boundaries, it is not intentional, but I do respectfully ask for any appropriate leniency since I am the underdog here today. May I please direct your attention to our opening contract labeled Florida Relocation, page 113, where it clearly indicates my promise to perform. If you look or read the contract, it clearly states I would prepay Stacy Lang $20,000 in lieu of Gianna's child support balance through her high school graduations. Payments would be made in 4 installments over the course of 18 months, and you can see the layout. Under her obligation to completely eliminate all future child support payments for me beginning November 1st of 2000.
Pellegrino,
Yes, sir.
that's in the record and we're able to review it and have reviewed it. I do want to have you address something that's on my mind. So there in the record, it shows that you provided the agreement, but we're an appellate court, and our only function is to review whether what we call the lower tribunal, which would be the circuit court, or in the instance of an agency like the Department of Revenue, an administrative law judge, or some member of that agency staff. And you've talked a lot in your briefs and a little bit in here about what you believe the department knew or should have known, should have suspected regarding the veracity of the child's mother's statements. But the only forum that the department could use to finally determine who was being truthful and not is a hearing. In other words, you may or may not be, or, I can presume for the sake of our discussion that you're correct that, maybe a reasonable person would have known that the child's mother was not being truthful in what she represented the department. But the department can't just make an off the cuff call and say, well, I think the father is more credible than the mother, or the mother is more credible than the father. I think the documents that have been submitted by both, after, we took a look at them and we think that the father is correct. The only method by which the department can make a final determination that we can review was in a hearing. And their argument, that goes to their argument that you need to address, which is the fact that you didn't request a hearing timely. Does that make sense?
It does, Your Honor, and I'm prepared to answer that. I mean, I can go right to the bottom line. I can save us a lot of time this morning, and it could actually explain all of that in detail if that's where you want me to go.
Well,
why don't you go ahead and answer, Mr. Pellegrino, go ahead and answer that, and then you can get back to your argument. But the most important thing to understand as a non-lawyer is your best argument is responding to questions that are posed by the panel, because those are the things that are most concerning to us. So go ahead and address Judge Atkinson's question.
Okay, I absolutely will. Your Honor, it wasn't that I did not, request a hearing. I actually did. And let me show you where. On April 29th, I received a package from April 26th, and it's on the record of page 84, proceeding to establish a support order. Item 4, page 85 says you have 20 days to request a hearing. I did not fail to request a hearing or waive my rights, because on April 30th, they had received a letter I submitted to them, and the letter actually states, I look forward to standing in front of a judge with Stacy Lang. The camp case notes 288 shows a conversation with the Department of Revenue on Monday, May 17th, that I did mean what I wrote. I agreed to proceed and intended to do so, and that I finally received all of the fronts and the backs of the cash checks that the Department of Revenue was looking for. But here's a very unforeseen, unfortunate, extenuating circumstance. That was Monday the 17th. On Tuesday the 18th, I suffered a heart attack. I required emergency open heart surgery. I had triple bypass and was placed in ICU. I was unconscious for 5 days. Okay. And while it's not in the record, okay, what I want to say is I didn't have the opportunity to go forward, although I had all my evidence. Needless to say, I was sent home in June with 35 staples in my chest, and with nurses, therapists, family, and friends around me constantly. I was just grateful to be alive and concentrating on my health, my mental, physical, and emotional stability. Now, it doesn't appear that the Department of Revenue knew that this happened to me, but Stacy Lang did. Did she have any responsibility to present it, to include and let the Department of Revenue know? It doesn't appear so, but unfortunately, the FAFSA went through, and here I am working since last July to try and get a hearing to present my case and all the facts. I hope that answered your question, sir.
Yeah, well, I mean, we're going to hear from the other side about whether a request was made in compliance with the statute. The statute says that the parent from whom support is being sought who fails to file a timely request for hearing shall be, and then that's what I was going to get to. We're here to hear your argument about whether you did or didn't request a hearing timely, and the department will have theirs. But what is a problem is potentially if if the Department of Revenue is correct that you didn't file one timely in compliance with the statute, that it says you're deemed to have waived the right to it. In other words, there's nothing that can be done after that. Once the timely request has not been filed, you're deemed to have waived the right to a hearing, and then it says the department can render an administrative support order pursuant to paragraph 7B, which lays out, in other words, the department can issue a support order of a final order, just like the hearing officer could have, if the parent fails to timely file a request for a hearing. Does that make sense? So in other words, you're right. I mean, if you did timely in compliance with the statute, file a request for a hearing, then the department would not be permitted to submit what under the statute is that final judgment, so to speak, which is administrative support order. But if you had not, then they themselves, the department, without a hearing officer, which is the equivalent of a judge in the executive branch, they can just issue the order, and they're going to do it based on what they have before them. Well, and so again, what is it? What is the so the opposing party can respond, and we can assess it. You gave us parts of the record on which you believe was evidence of your request for the hearing. One was in the notes of call notes. Is that right?
Yes, sir.
And then the other one was a specific correspondence that you sent to them. What record page is that?
That is page 84.
Okay.
And yes, sir.
Page 84 of the record?
Yes, sir.
Okay, we can definitely look at that.
Mr. Pellegrino, I'm actually looking at it, and that is the notice of proceeding to establish administrative support order.
And it's 85, sir. 85, page 85.
But that's still part of that same correspondence from the department to you.
Judge Smith apparently found it on page 110. And it says, I look forward to standing in front of a judge with S. Lang.
Yes, sir. It's a handwritten letter when I sent the contracts, the check again, to show them that I was ready to proceed. I wanted to proceed, but unfortunately, again, because of my circumstance, I mean, I did have, from the date I received the information, I did have 20 days to respond. Unfortunately, I think about on the 18th, 19th day is when I suffered a heart attack. I got shortchanged. You know, and I'm not arguing rules and laws. Okay. Unfortunately, I guess, you know, what I'm arguing against is, you know, everything funnels down to a technicality. And this technicality is the difference, you know, me proving that what I did is the absolute right thing and did pay the child support up front versus me being accused of not paying it and having to pay it again. So that's where this whole thing boils down to. And that's why I'm just trying to lay out all the facts and the information so that you can see what I'm up against.
Anything else you'd like to add before we go to Ms. Bernstein?
Your Honor, it seems, you know, everybody knows the facts, you know, the timeline. Okay, you know where I stand and why this happened to me. Okay, all I'm saying is that I did make the payments, and unfortunately, because of a unfortunate situation or a technicality, I'm being accused that I didn't and asked to pay again. And the person that's going to be impacted the most, unfortunately, is my daughter, Gianna. And that's the end of my argument for now, sir. Thank you.
Very good. Thank you, Mr. Pellegrino, and you'll have your 5 minutes for rebuttal time. Ms. Bernstein, you may proceed.
Your Honors, Tony Bernstein for the Department of Revenue. First, let me clarify, the department never called Mr. Pellegrino a deadbeat or anything like that. They are, under the law, allowed to enforce the child support order while it's up on appeal. So while he's complaining about a levy the department was within its rights to do. Mr. Pellegrino now is for the first time claiming that he asked for a hearing. So let's talk about his April letter. That letter came following his receipt, the service of the notice of proceeding to establish an administrative support order. The clock for requesting an administrative order an administrative hearing hadn't even begun because there was no proposed order entered yet. So when the department received that letter, they contacted Mr. Pellegrino, and this is in the notes, and asked him, are you asking to opt out? And he told them no, because that's what it would have been timely for. It was premature for an administrative hearing because no proposed order had been entered, but it could have been an opt-out. And so the department contacted him to clarify that. And he said no, and the notes show that he said he would wait and see what the proposed order was. The department entered the proposed order. They had advised him time and time again about his right to ask for a hearing, and he didn't ask for it. I am not going to question whether or not Mr. Pellegrino had a heart attack, but there's nothing in the record that he ever contacted the department after even receiving the final order to say, wait, I couldn't have made the hearing. And in fact, the department had even waited an additional week to enter the final order. They gave him more than the 20 days that they were required to allow to see, number one, if he would return a copy of the back of the check, or if he would ask for a hearing, and he never did. So having failed to ask for the hearing, he's waived all the arguments that he's made now for the first time on appeal. So we'd ask that you affirm the order.
Well, could you walk me through this? I do agree with you that it seems that the specific argument based on a specific document Mr. Pellegrino has turned our attention to was not made below, but I think on page 110 of the record, that's dated April 30th. And then page 85 is the letter from the department he had been referring to, which is like you said, it's just starting a proceeding. And what you're saying is that, yes, you're acknowledging that the department did receive that handwritten letter, but that is not the, and he was saying that the correspondence, let's see here.
Judge Atkinson, while you're looking at that, I just want to make certain, Ms. Bernstein, what I'm looking at in terms of what you believe starts the clock is the income deduction order that was entered in, that's at record 180. I'm trying to see the date on it.
Your Honor, are you talking about what starts the clock to ask for a hearing?
Yes, was that the final administrative support order?
Okay, so that would be the proposed order that's sent out. That's when
which one is that in the record? Because I'm looking at the final support order.
Okay, the proposed order is on page 136. That's the copy that went to the mother, but that's what starts the clock under the statute.
So it's the proposed order.
So you have 20 days from the mailing of the proposed order to request a hearing.
Because that was June 3rd, and then it looks like the actual order was entered, or what I'll call the final administrative order was entered June 30th. Is that right?
Final administrative order was entered.
That was 185, did you say? No.
180.
Yes.
Okay, the final administrative order was
One at 164.
Well, the final administrative order is on the rendering page is on 181. That's the day so that was June 30th.
Yeah, well, there were several things entered starting at record 164. There looks like about 7 or 8 documents all entered on June 30th. And so the time frame that you want us to focus on is in between June 3rd and June 30th, that there was nothing filed on behalf of Mr. Pellegrino.
Between when the proposed order was entered and was mailed, and that was
And there's a proposed order summary sheet dated June 1. Then there's a proposed administrative support
so-
order and so forth.
Between the date when it was mailed and when the final order was entered, we received nothing.
So I want to make sure we're all on the same page. Are we talking about the time frame between June 1 or June 3 of
Okay.
2021 and June 30th of 2021?
All right. The proposed order was mailed out on June 3rd. The final order was entered on June 30th. So he would have had until June 23rd. After the 3rd, he would have had 20 days to request a hearing. At the time that he filed, he had only received the notice. And if you look at the notes on page
85.
No. I'm looking at DOR's notes, sorry. On page 288. It shows that after the department received Mr. Pellegrino's letter, they contacted him and they asked him exactly what he was asking them to do. And he stated that he was only sending information to notify the department that he was not going to pay child support and he was not going to return any documents, which he did not. He did not provide a financial affidavit. He didn't provide a parent information form, which would have shown he could have put down what he paid. He didn't provide return the standard parenting.
Miss Bernstein, let me, this is on, my question is directed to the proposed order that was attached to that April letter. And if we're referring to the proposed order, I realize it's not issued yet, but the language, because under the respondent's notice of rights in paragraph C says, if you disagree with this proposed order, you may ask for a hearing by filing a written request with the deputy at the following address. Your written request must be received no later than 20 days after the issue date of this proposed order. Is that somewhat ambiguous to say here, because the order, it doesn't say it has to be executed or issue, the time period for responding to the written request is simply no later than 20 days after the issue date. So I understand your argument of that it was premature. I'm just wondering, in the notice of rights, what apprises a party that you can't file it early, that it has to be only within the window after the issue date of the order?
I mean, I'll look back at the statute, but the department puts in what the statute requires. The statute requires certain language. And I don't believe that it specifies that, if the right starts when the proposed order begins.
Well, and I recognize what your argument is, but in looking at the material that was provided to Mr. Pellegrino, if this proposed order is attached and it has this language, I'm trying to, see how it apprised him he had to wait. He couldn't prematurely request a hearing.
I'm looking to see exactly what the statute says. It says, the department shall provide a notice of rights with the proposed administrative support order, which notice must inform the parent from whom support is being sought, that the parent from whom support is being sought may, within 20 days after the date of mailing or other service of the proposed administrative support order, request a hearing by filing a written request for hearing in a form and manner specified by the department.
So after the mailing of the proposed support order. Is that?
The notice is in several places. So let me see.
Talking about 5C1, the
Yeah.
parent from whom support is being sought within 20 days after the date of mailing or other service of the proposed administrative support order, a request a hearing.
So that seems, if it's a proposed order, that means it's not issued. Do I have that right?
Yes, it's not a rendered order.
Okay.
It's just,
And so would it be timely now, given that what you've just read?
under the statute, I don't believe it was timely. I also don't believe that it was intended to be a request for an administrative hearing because the department did contact him and asked him what he intended it to be. There's also notes that he later said that he would wait and see what the proposed order came out with. Now, if you're now questioning that maybe this should be written a little better, I can see where there might be.
Well,
some-
I think what you've just pointed out, it doesn't necessarily track the statute.
Well, it also says on the first page, 136, request a hearing by filing a written request within 20 days from the date of this proposed order. I mean, I think that shows that it's looking to go forward from the 20.
Well, but it's still saying proposed from this proposed, and it's proposed here. So anyway, I'm just at least pointing out there might be the language in the notice might be ambiguous. You can certainly argue with me on that point, but.
Well, I mean, Your Honor, in light of what you're pointing out, I might ask the court if you'd relinquish jurisdiction for 30 days for me to discuss this with my client. It wasn't brought up below, so I couldn't address it then. Mr. Pellegrino did not raise any of this. And that may be a way to resolve this.
Well, okay, so but what we're looking at is that depends on what we have the authority to do or not do, regardless of whether you say we relinquished jurisdiction to the department.
Yeah, I mean, this is a new argument that's brought up. It wasn't brought up by Mr. Pellegrino. He never made the argument below that he had asked for the hearing. None of this was brought up. I can see where the court's confusion is. It may be better for everybody if you.
Well, let's talk about what the confusion is. Okay, so he sent notice essentially. Let's just talk in the vernacular. He sent notice of that there's a case pending against him. Hey, there's a case. Mother or child is seeking support. What do you want to do about it?
Okay, so, but there wasn't a case. I'm sorry, Your Honor, go on.
Well, go ahead. You can describe whatever you want. There was.
No, I'm
and
just
then
saying
he-
the department asked him, he also said there was already a child support order. They asked him to produce it. He never did. They were not able to locate a case. The only case that's out there is a civil case where he was then suing the mother, I guess, on a contract theory, which was.
No, what do you want? Whatever you want to call. What do you want to call your Let me go back to the your letter of April 26th, notice of proceeding to establish administrative support order. I don't know what you want to call that. I called it a case, and if you think that's wrong,
You mean an administrative case? I'm sorry. I
yes. So, and then 4 days later, and then we're not talking about the call logs or anything. The respondent, I guess he's not a respondent. Mr. Pellegrino says in a written filing, a letter says, I look forward to standing in front of a judge.
Okay.
And then but that's not all we have in the record, right? We have other things. We have other correspondence or at least communication between the department and Mr. Pellegrino. So, and you have said that had some bearing on whether we should consider that written letter saying I look forward to appearing in front of a judge as a request for a hearing under the statute.
I would dispute that could be considered a request for a hearing because the proposed order hadn't been entered yet, so there's nothing to dispute at that point. it could have been a request for an opt-out to go into circuit court rather than stay in the administrative arena. And the department contacted him to verify whether or not that's what he was asking for.
Well, what's this? What could you direct us to the statutory? That's that under 409-2563, the
Yes.
opt out. Then what? Remind me what subsection that is. Judicial. Wait, go ahead.
All right, so
We have.
it's under, wait.
A notice of proceeding in subsection 4.
Oh, you know, it's also interesting because this statute also talks about, well, I kind of got away from what you were asking me.
Yeah, let's go with what I'm asking first, and then we'll go to that.
All right, give me 1 second.
If the parent for whom support is being sought files an extra. Okay, so but suffice it to say, since we're having trouble finding it, that one option for a parent is to say, I would rather, and rather than let this proceeding go forward administratively, I'd like to go to court, a judge.
Your Honor, what you're looking for is N3, I guess. It says, if the parent from whom support is being sought submits the requested authorization in subparagraph 1, so that's under N, yeah. That it's the opt-out is a two-part proceeding, so they would request that it go into circuit court. The department would file a petition in circuit court. He would then, the obligor, potential obligor would then have to file a waiver of service.
So in other words, the parent, Mr. Pellegrino, wrote a letter saying, I look forward to appearing before a judge. And you're telling this court, as presumably you did below the department, that there is evidence that the department reached out to Mr. Pellegrino and said, are you asking to appear in a Article 5 circuit court?
Yes.
Yes. And he said, no.
Right.
Right. And he said, I'll wait to see what the proposed order says.
Mhm.
Right. So it's possible for us to infer from that, as the department did, that his letter written on the 30th, the meaning of that letter was clarified by a conversation with the department, who asked whether that letter was a formal request to go before a judge, and that conversation regarding that letter, including a discussion of that letter, included a question from the department about how he wanted to proceed. And he didn't say, I know I want an administrative hearing. He didn't say anything of that sort. He said, I'll wait to see what the proposed order says.
Right. And I'd also point this under 4J, it also says that the request would have to be after the service of the proposed administrative support order for hearing, so that the parent from whom support is being sought does not file a timely request for hearing after service of the proposed support order. The department will issue an administrative support order that incorporates the proposed order.
It seems like the two timeframes that the court is circling around is the first one being a request to go out of the administrative process into the court process.
Right.
And Mr. Pellegrino's letter, to be kind, was ambiguous as to exactly what it was asking for, but maybe it could be interpreted as an insistence on going to the circuit court. However, when there are further proceedings or letters coming from the department, there's nothing from Mr. Pellegrino saying, wait a second, I've asked to go into the circuit court. Why are you still sending me anything? So I mean, that's one thing that honestly is concerning to me. Then the other is when the notice comes out of proposed order in June, then there's not a within 20-day request for a hearing based on what's in the proposed order. And I candidly don't recall if there would be any potential for, after the order is entered, for him to say, wait a second, I was in a medical emergency, I could not act. Some sort of relief from, post-order relief. I'm not sure if that's even available, but there is nothing suggesting that request for post-order relief.
I think he could have done that. Instead, he
He
never,
filed
he
the
did not
notice of
notify,
appeal.
there's no one, okay. I think if he had filed or notified the department of that quickly, they could have gone ahead and looked at that as a rehearing and vacated the order.
So your
Well,
time has come.
but now, the problem is there's no 1.540 in administrative.
Right. Well,
But
and
now the question becomes, was he denied I'm sorry, Your Honor, go on.
no, I mean, we've come to the end of the time, but I want to ask a question going back to something that was raised earlier. You had said, well, if there's I'll paraphrase it. If there's some confusion here, maybe we ought to relinquish jurisdiction and let it get clarified. And I think Judge Atkinson raised the point, do we have the authority or the jurisdiction to do that? Because I am not certain that we do. And so what's the department's position on that? Is there authority for us to relinquish jurisdiction or send it back for further clarification?
At 120.68,
I'm sorry. I
in
didn't hear you.
120.68, are we under 120.68?
Well, I don't know, but I know I've done this in other appeals throughout the years.
Right. In other words, under the Florida Administrative Procedures Act, is that what you're proposing? In other words, what is that the authority?
No, I'm under the appellate rules. You haven't issued a decision yet, so I'm asking you to relinquish jurisdiction. And
Not in other words, not final relief under 120.68 under the
right,
which could include remand to the department with instructions. You're saying relinquish jurisdiction pending a final order. So my question would then be, if that's the case, then my question would be, what could or could not occur at the lower tribunal, which is the department, that would change what we could do about somehow granting relief from a final administrative order of the department.
Once jurisdiction is returned to the department, and I discussed the apparent confusion with the language, maybe that my client wants to settle rather than have an order that comes out that starts to put the language in question.
Okay, but under 120.68,
are we under 120.6? I mean,
I'm asking you because this is an appeal. I think I saw that, but we have our ultimate relief can be honestly more flexible than just a straight up an appeal of a final judgment of the circuit court. If it's under 120.68, we have multiple options about what but that's something distinct from relinquishing jurisdiction. That's saying, okay, this appellate case is done, and we're remanding to the lower tribunal, which would be the department, to do X, Y, and Z. So we would have to think about that.
You're talking about just coming out with a regular opinion?
Yes.
Okay.
Well, and just to weigh into that, the concern I have from a legal standpoint is we would remand if we find that there's either the fairness of the proceedings or the correctness of the action may have been impaired by a mere material error in procedure and so forth, which I think is the provision Judge Atkinson is looking at. And I think ultimately it becomes the question of interpretation of the notice from the department that preceded Mr. Pellegrino's letter and what he said in that letter, and then the inaction that occurred when the notice of proposed order was subsequently issued. And so this may be an effort to fit the proverbial round peg into a square hole. I'm not sure it fits very neatly. Anything else?
So the order.
Is there anything
Sorry,
else
Judge.
Nope. Is there anything else from the panel? I've let it go on a bit longer, and I'm fine to let any additional questions get fleshed out because I think it is an important issue. So Judge Smith.
I just if Ms. Bernstein wants to, I guess, file a motion for relinquishment for us to consider, then then maybe that's something we should look at, as opposed to you just on the cuff right now. I don't know, but I would be inclined to look at what the motion would state.
And I mean, I could propose, we can talk about this in discussion. I mean, about if there's supplemental briefing on what relief we could grant based on, the flexibility of 120.6A. I'm not asking that right now, but I mean, I could ask my colleagues. But the problem right here, Ms. Bernstein, and we're also, speaking to you, Mr. Pellegrino, as we speak, you're listening, obviously. So, I mean, what Judge Silberman brought up, and I don't want to speak for him, is that often our hands are tied. We can't just go on forever trying to reinterpret what happened in the lower tribunal, which is the department. We only have so much authority that's been granted us by statutes in the Constitution, and what the record shows is that on April 26th, there was a letter sent to you, to Mr. Pellegrino, that said, you or the other parent caregiver may file a civil action in an appropriate circuit court at any time to determine your paternity and your support obligations, if any. If within 20 days after you're served with this notice, you file an action in civil court and service with a copy of the petition, this administrative proceeding will end and the action will proceed in circuit court. And then in response to that, you sent a letter saying, I look forward to going before, to being with Ms. Lang in front of a judge, which would suggest to the department that you were requesting what that letter informed you was one of your options, which was to go before a judge. And they called you, and according to the logs and according to what the department's saying now, and according to what seems to be in the record, they said, hey, are you asking to go before a judge? And you said no. And you said, instead, I'm going to wait to see what the proposed order is. And then you have additional rights. And in that proposed order, you were informed that you had another choice to make, separate and distinct from the choice in the first letter, in the first notice. And that choice was whether to request an administrative hearing. And you concede now that you did not file a request for an administrative hearing during the time after you received the proposed order. So, we've talked about, we had a robust discussion about what is or is not possible. It just may not be possible for this appellate court, to do anything, whether we relinquish jurisdiction or not, but we can certainly consider that.
If there's nothing else from the panel, Ms. Bernstein, is there anything else you'd like to add before we go back to Mr. Pellegrino?
No, Your Honor.
Very good. Thank you very much. Mr. Pellegrino, you've got about 5 minutes to wrap up. I think you've, to use Judge Atkinson's words, you've heard a robust discussion of these issues. And clearly, we want to try and get to the right result, but we do have constraints on what we can legally do, much as you have certain obligations under the law to comply with the requirements that are posed to you. And there's a question here as to whether you timely complied. So with that sort of laying the groundwork, is there anything else you'd like us to know?
Yes, sir. First, I have to say, I'm in absolute awe of your interpretation of the law. It's absolutely phenomenal. I got some education today. Not attending law school, I just knew the difference between what's right and what's wrong. Anyway, like I said, I'm not an attorney, but I was prepared to get in front of a judge at that time before my heart attack, because I did finally receive all the fronts and backs of the 4 checks, which proved that I did pay her, which the Department of Revenue was looking for. Unfortunately, I was not able to present them because what had happened to me. I do have the 4 checks available if the court deems it necessary to take a look at. If not, the only thing I'm asking, and I don't know what remedies this court has to provide me in this particular instance, but please send this case back down to the lower court. Allow me to present all the evidence I have to show that I did truthfully and actually pay that $19,000 as I have stated. And this case will finish up and this FAFSA should be dropped because honestly, I did. And if we want to get to the bottom of the truth, I can prove it with those checks. And also if Stacey Lang is present in the court to answer in front of a judge as well. Other than that, I thank you, Judge Atkinson, Judge Smith, Judge Silberman, for your time, your consideration. This was an unbelievable experience. And I hope I've shown you enough to at least give me the opportunity to present myself and protect my daughter. Thank you, everyone.
Judge
Mr.
Silverman,
Pellegrino,
Judge
yeah,
Silverman,
Yes, Judge.
this is
Atkinson.
this is unorthodox, but could I ask a question of the parties?
Yes.
Okay. Because something unorthodox was proposed by one of the parties, and I want to represent to both parties as an individual member of this panel. We have made no decision on whether to relinquish jurisdiction, on whether to affirm or whether to reverse. We've just been having a discussion. But under subsection 6, 409 the statute, it says if the parent from whom support is being sought files a timely request for a hearing, or the department determines that an evidentiary hearing is appropriate, the department shall refer the proceeding to the Division of Administrative Hearings. Now, Ms. Bernstein, do you believe that a failure to request a hearing within 20 days after receiving the proposed order somehow extinguishes the department's right under subsection 6 to itself determine that a hearing is appropriate? I don't know the answer to that,
I
but
don't
I'm
think
just
that we're under that. I think at this point,
because of the
I
time
think
frame.
the argument that Judge Smith has brought up puts into question a due process issue. And based on that, the department would have authority to still vacate this order.
Let me
Because although
suggest,
there is no 1.540 in admin, there is case law that talks about how the department, that how agencies do have the right to come back and vacate.
Right. In other
orders.
words, sorry to talk over you, but in other words, what you're saying is you can't now exercise your independent authority as a department to hold a hearing on an order that's already been issued.
Right, we would vacate the order.
Right. So we're under 120.68 or under relinquishment or something like that. That answers my question.
let me
But,
suggest-
right.
let me
Go ahead,
suggest
Judge.
this further. Mr. Pellegrino, I know you had offered to show us the checks. We're not a fact-finding court. We review the law and how the law was applied in the case. So I hope you'll understand that, no, we won't be looking at the individual checks to make a factual determination. But what I will also suggest is the panel will confer, and Mr. Pellegrino, this is for your benefit, just understand, we don't make a decision right here online. We confer at the conclusion of this. Our decision, if any, is rendered. It wouldn't come out for a short period of time, no less than a week or 10 days, which would give Ms. Bernstein the opportunity to take a look at what has been raised today and whether there's something she is able to file on behalf of the department that might assist us in coming to the right decision. The other option for her and for the department is, and for you for that matter, is we can always issue an order for supplemental briefing if we decide that's necessary. So there are things that we as a panel have to talk about. And in the time that we are talking before any decision is rendered, parties are entitled to file other things that may or may not cause a change. What they don't get to do is provide further argument. But there might be some basis for the department in particular, but you as well, to present something to us that was raised by this argument. Generally, I think at this point, it would probably be from the department because, as you said, you're not a lawyer. You may not have the training to dig into some of this, but I don't want you to feel that this is one-sided either. So both parties have certain opportunities, but we're also bound by what the law lets us do and what jurisdiction and authority we have. So unless there's something else Judge Atkinson or Judge Smith wish to weigh in, or if I've said something that confuses anyone and you want to ask a question, you certainly may. Mr. Pellegrino?
Your Honor, real quick, and I apologize, and then this is my last question or statement. I was a little confused about earlier when Ms. Bernstein and you were talking about the time dates and when something should have been in or not in. I was prepared at the time before my incident to submit all my paperwork, submit the case, the evidence, okay? Unfortunately, I didn't, but if the record shows and they take notice, they did receive my appeal within 14 days after June 30th to show that I was that ready. And that appeal was over 70 pages long. You don't put that together in a week, especially over a 4th of July holiday weekend. I was ready to go. Unfortunately, I didn't hit the cutoff date because of what happened, but I welcome and respectfully ask for the opportunity to present it now that my house is in order. Thank you. Thank you again, Your Honors.
Thank you. And I'm sure if your daughter has spent any time watching, she has seen that you have fought for what you believe is correct. And ultimately, we all want the right decision, but it has to be within the bounds of the law that bind us as well. So
I'm grateful for your time in the hearing.
you're welcome. And
Thank you, Ms.
Mr.
Bernstein.
Thank you both. That concludes this presentation. We are adjourned. Thank you very much.
Thank you.